Hello, everyone. Welcome back to Season 4, Episode 2 of our Association Leadership Series. I want to welcome back from some travels, I think, Donna Berger DiMaggio, a shareholder with Becker Law Firm. Donna, welcome back.
Thanks, James. Good to be here. Thanks so much for having me.
We really appreciate you joining us, and we really appreciate our audience who have been so incredible. Keep coming on our webinars for almost 3 years now, Donna. And one of the things we did last year, because we've covered so many different topics, obviously the reserves and the Senate Bill 4D recently, and we really noticed the questions that are being submitted are so varied. We thought, Donna, let's do a town hall. Let's do an open forum. So what we've done is we've kind of synthesized the questions you submitted, and then I see Hank's already put one in here. So please, we welcome your question. I'm monitoring them as they come in, and if I see a kind of a grouping of the same, I'll do a question like that. So we both have some questions that you've submitted and the ones that are coming in live. We also get asked a lot about past episodes. They are all up on our casagroup.com. Just go to resources and webinars. In fact, there's a question, will this be recorded? And the answer is yes. By sometime tonight, it'll be up on casagroup.com. I also want to remind everyone that Donna is sharing her brilliance. Unless you're a Becker client, she's not giving you legal advice, but it'll be a great conversation.
And even if you are a Becker client, please email me.
Yeah, you got to pay for that, right, Donna? So, and then most of our audience is Florida-based. We have a few from Texas, and a lot of topics today will probably be universal. But for the most part, as it relates to law, it'll be Florida law. And any questions that you don't have that you haven't put in through Q&A, please just email them to info@casagroup.com. So the other thing I want to say, Donna is our last episode before Thanksgiving. So I want to wish everyone, because I'll probably forget or be too time squeezed at the end. Happy Thanksgiving, everyone, and to you, Donna.
You too. Happy Thanksgiving, everyone.
So I hate to start these questions off on kind of a downer question, but we had a newsworthy event in our industry in Miami-Dade in the last 48 hours where several board members were arrested for absconding funds down at the Hammock HOA, which is terrible, obviously. And really, Donna, I think the primary crimes were a board member using association funds for personal expenses and payments to a vendor that wasn't really a vendor and was related to a board member. And again, I'm summarizing it, but this could apply to any, hopefully not, but any community. I'm just using it because it's so highlighted, and we had several questions. And really, I just want to kind of begin, Donna. What can our board members do to make sure that doesn't happen in their community? Do you have some thoughts on that?
Well, I do. I want to preface this by saying that I'm not commenting, James, on that particular news story that made headlines yesterday. I'm not affiliated with that community, and I don't know anything about, particularly other than what I read as to what took place. So my comments that follow are general in nature, but you've asked what can boards do to kind of prevent or root out fraud, and it's an incredibly important question. When we teach board certification classes, that's one of the components. And I discuss what's called the fraud triangle, James. And that consists of it's a triangle, so it consists of three things. The first thing it consists of is opportunity. So who has an opportunity in the community to potentially commit fraud? Normally, that's a person who's in a position of trust. It could be a board member, it could be an outside vendor, it could be, it could be the manager, it could be the treasurer, but it has to be somebody who has the opportunity to actually commit the fraud. The second part of the fraud triangle is incentive or motive. And normally, James, that involves financial pressure, which given, the economy and what we've seen, if somebody's under financial pressure, that becomes the second part of the fraud triangle. That person who maybe have the opportunity, now that person has an incentive. There may be bills to be paid. There may be an illness in the family. It could be any number of issues, but it's something that's contributing to financial pressure. And then the third part of the fraud triangle is the most interesting because it's rationalization. So the person committing we'll call him or her the fraudster, rationalizes their activities. Well, I haven't gotten a bonus in a year. I'm doing all this work. I'm being asked if maybe if it's a volunteer board member, I'm doing this without any pay, or they're rationalizing, I'll take it and I'll pay it back. So once boards understand the fraud triangle, then you have to have some checks and balances in place. Now, you mentioned, James, did you say that there was a company where they had two different names, or a shell company?
It's not too explicit, but it sounds like one board member was related to someone who had a company that was a shell, and they were just submitting invoices and paying it from association funds. That was, again, all I read was what's in the press, what our audience has read.
You have no inside knowledge. So you've hit on two really important points when we're talking about fraud. Let's start with collusion. So when you've got collusion where somebody recommends somebody and they come in, that can increase the chances of the amount of money that's lost going up exponentially. Now, this is not to say that you do not currently have good employees who know other good employees that you may want to bring into the community. I'm not saying that, but I am saying that when there's collusion, when you have more than one person in the community working to effectuate the fraud, the losses can be considerably higher. Secondly, is what seems to be a setup is using these shell companies. So either you overpay for work that's never been performed, or let's take an example, ABC Roofing Inc. I don't know if there's a company called ABC Roofing Inc., but I'm not referring to
I hope not.
ABC Roofing Inc. is the company that was hired, and you see checks going out to ABC Roofing LLC. That's another way to perpetuate a fraud. A lot of these frauds take place, James, because there are not checks and balances in place, and nobody is reviewing the actual statements. Like I said, that if you're looking quickly and you're just looking at ABC Roofing and you're not looking at the rest of it, you may not catch that. As well as not looking at credit card statements. I believe in that case that there were a lot of personal expenses that were not checked. You need to be looking at the credit card statements. Also, keep your credit card limit very low. There's no, some boards I talk to, they have $5,000, $10,000 credit limits. There's no reason for that. And as you know, the Florida legislature outlawed the use of debit cards a few years ago for this very reason, to prevent fraud from taking place, because there's no intermediary with a debit card. It comes straight out of the bank.
It's just such a terrible situation. We're having a tough enough time keeping maintenance fees reasonable with all of the other expenses. And obviously in this community, they're going to have to deal with that. Hopefully there's some insurance. I'll make, I guess, a shameless plug for management companies. And I don't just mean ours. Our industry does provide another layer of control in that no invoices go to the board for signature until they've been approved by the manager. So that's important. And the other advantage of having a management company is most management companies would separate the person that pays the bills, the person that collects the money, the person that does the bank rec, and the person that does the financial statement. And those are basic accounting controls. So that is obviously for our self-managed community something to think about. There's a question that was on the board here, Donna. Should the management company be bringing the vendors in, or should the board? And there's obviously some suspicion, but look at, we have a process. It's actually a technology called Vendor Smart that we utilize so that every vendor is vetted. And I think whether you're self-managed or not, you can use a software like this and a firm that does the checking.
And it's a collaboration. I mean, obviously, many of my communities rely on managers to vet and bring them vendors, but ultimately it's the board decision as to who they want to hire. And ultimately, any vendors you bring in are going to be working on behalf of the association, and the association is the one that will ultimately be sued if something goes wrong. Just to tie in to what we've been talking about, James, in previous episodes regarding SB4D, we know one of the major results from SB4D is going to be a huge increase in the amount of money sitting in reserve accounts throughout Florida. I mean, we're talking hundreds of millions of dollars. It's already starting because people are getting ready. Starting in 2025, those reserves are no longer waivable. So what does that mean from a practical standpoint is now you're going to have a lot more money sitting in the bank. Everybody needs to check their fidelity bonding. because that's an important point of this too, in terms of fraud prevention and recovery from fraud. Anybody controlling or dispersing funds in your association needs to be adequately insured with a fidelity bond that covers all available funds at any given time. And my point is, there's going to be a lot more funds available now post SP4D.
Yeah, I really like to highlight actionable take homes, and this is a big one. I believe it's law, right? Our fidelity bond has to equal all of the funds that we have in the association, and we are going to have more funds after SB4D. So we all need to take a look at our fidelity bond and make sure it's at the appropriate levels. The other thing I want to mention is credit cards. Credit cards can, tend to not get as much scrutiny. A charge is on there from Home Depot, it all looks perfectly fine, but controls can be put in place there as well to make sure, in fact, that those funds are being spent on the association.
Well,
Anyways,
ask some questions. If somebody has bought oil, what are you oiling?
Yeah.
What are you using it for? If you don't have anything for what the charge stands for, you need to ask questions. That is a big problem. I just talked about that on the podcast with Michael Ryder, who's the former Palm Beach chief of police, and he did a whole section about fraud prevention. And that was one of the things he mentioned, is that people are reluctant to ask questions, but you really can't. It's not your personal money. You are, board members have a fiduciary duty. They are supposed to be safeguarding the funds of the association. So that's a significant role.
Okay. I think in our discussions in preparation for this webinar, Donna, you had brought out, we're kind of moving from fraud, which is there are things you can do to control that, and then insurance to mitigate any loss. But it also kind of ventured over into code of conduct in terms of how boards operate and how owners operate when they're in meetings and on Zooms. But before we go into that, there's another question on the board is, can a board member or board members spend money without approving it at a meeting, and or can one board member, and I think that in this case it was the president, can they authorize expenditures without full board approval? So before we get into code of conduct, those two specific questions about can you spend money without approving it in a board meeting, and can a board member, often the president, authorize expenditure without board approval? Those are two different questions.
Both great questions. And here's what you can do about that. Developers, work off of cookie cutter documents. So a lot of times they do not clearly outline board member duties and scope of authority, particularly for officers. Now, some do, okay? But one of the things you can do as a community is sit down and talk and maybe amend those sections that pertain to what's the president's real role? How about the vice president? What does the secretary do? What does the officer do? I've had clients say to me, board presidents say, I am the CEO of this corporation. And I'll say, well, that's not really true. Until one day I looked at a particular set of documents and it actually did say that the president was the CEO. Of course, it didn't say what that meant. So this is where policies and protocols come in, James. As a board, you can pass a resolution. For instance, if it's a community like in Southwest Florida, we have a lot of seasonality. We have a lot of seasonal occupation throughout Florida. But if you know you're going to be gone for an extended period of time, and there's going to be one board member in residence full time, that board may want to pass a board resolution saying, we approve, so-and-so, the in-resident board member expending money, but up to a limit. So again, it all is going to depend on the type of policies and protocols you put in place. Now, for the person who asked this question, if there are no policies and protocols in place, and you've got, board members doing these things on their own, that can be problematic because you always have to trace a source of authority. Where's the authority for, so-and-so doing X or Y?
Yeah, I think, my management advice would be, if I'm a board member, err on the side of caution. There aren't a lot of emergency expenditures, and if they are, they can be dealt with in that manner. We have a budget. We know what's going to happen in the next month. We generally meet monthly, and I would encourage all board members to kind of get those things approved in a meeting. Obviously, there'll be exceptions to that. Talk to me a bit about this idea of a code of conduct. What is it, and why would I as a board member want to have one?
Well, it's a perfect segue from what you just said, James. So, a lot of times in terms of expediency, board presidents, it's usually the board president, but not always, but board presidents will make a decision, for the purpose of expediency. But he or she is really flying without a safety net. So to the point you just made, which is so important, bringing it to the board and having the board discuss it and vote on any particular decision is the board president's safety net. Because as well as I do, you're always going to get criticized, right? And it's one thing to say, I personally made that decision, as opposed to, we discussed this as a board and we decided as a board. That's not to say that for minor things, again, have a policy where you don't have to call a full board meeting on every little thing. Board member codes of conduct are becoming much more important. And I have to tell you, James, we've done webinars with Andrea Northrup. We've talked to her about this. I know you talked to Joel Meskin, other, experts in the industry. They're looking to ensure, in terms of directors and officers coverage, boards that play well together. They don't like the dysfunctional boards where you've got factions 4 versus 3, where you've got people on the board that will be leaking confidential and privileged information to other residents in the community or to vendors that the association is involved in litigation with. By the way, if anybody's listening and you're like, dysfunction on the board, what are you talking about? Good for you. But I think you're in the minority in terms of having a highly functional board. For most associations, there is some dysfunction on the board because not everybody sees eye to eye, and that's okay. Having that back and forth is okay, but you do need to have some sort of a framework. Remember, developers don't build that framework into their documents. They want their documents as open and loose as possible to appeal to as many people as possible, which is why a board member code of conduct, which outlines the type of, who speaks to whom, how do the board members interact with each other? There's certainly room for civil discourse. There's no room for threats, profanity, things like that. The same applies to how they conduct the meetings. What about handling privileged and confidential information? How do they speak to and interact with vendors? So all of these things can be incorporated into a board member code of conduct. I will only say 2 more things. The board of conduct can be adopted by a majority of the board. Not everybody has to sign off on it, but if a majority adopts it, it's going to apply to every member of the board, including the people who refuse to sign it.
I'm going to segue. That's excellent, Don. I'm going to segue here because there's a couple of questions. Not everyone on our audience are board members. Some are of course, homeowners and unit owners. And there's a couple of questions here kind of around the board isn't listening to me. So again, I'm going to have a 2-part question. What's the obligation of the board to listen to the owners, and 2, should there be some protocols about the civility of the ownership group, just as there should be for the board? So I must be coming up with 2-part questions all day today, Donna. So
that's okay. I'm ready for you. So let's start with the first one. The board's not listening to you. 1, are you attending board meetings? So, you have an opportunity under law to be heard and speak on agenda items at board meetings. This applies to condos, co-ops, and homeowners associations. So they cannot shut you out completely. Unfortunately, some boards leave the Q&A until the end of the meeting. I am not in favor of that, because the whole point of going to the meeting is to be able to speak to an agenda item before it's actually voted on. Now, will you change any board members' votes or minds? Maybe not, but at least in my opinion, that is the way to do it. And by the way, your governing documents, once again, may require that to be the case. So you always have to look to the documents first. The statute doesn't say in what order questions may be taken, but it does say for 720, for instance, says that every owner has the right to speak on an agenda item. Now, the boards can pass rules saying how long you can speak, where, how you have to videotape, things like that. Sending emails as an owner, right? They're not listening to me. Well, you may want to think about your communication style too. If you're sending, 22 paragraphs on emails and you're sending them daily, that's actually counterproductive. By the way, for the people in the audience who are owners, there is no legal requirement that the board or the manager respond to your emails. There's nothing that says they have to respond to your emails. They have to have a meeting and take these things up on an agenda, but it's voluntary to respond to an email. Now, if you send under 718 a certified written inquiry, then the board must respond to that, but they've got 30 days to respond or 60 days to respond if they've got if they need the assistance of counsel or the DBPR to fashion that response. So those are really the ways. And lastly, if the board's not listening to you, run for the board. Try to get a board in who does listen to you. So that's always an impetus for change.
Before you go into the civility part, again, the questions are all coming in as you speak. And so ultimately, the owner's action they can take is run for the board, get elected and be the board. Obviously, in most documents, there's a provision to recall a board, but honestly, it's just easier to get your group together and run yourself or run a slate. And that's ultimately, I mean, ideally in a community, you have a board that's communicating really well, and it tends to take the energy down. And if they don't, they don't. And, you know, we manage 450 associations. I always use the 1% rule. Even if we have an occurrence of 1%, it's 4 associations experiencing the problem. So we probably have 4 associations where we've got a significant group of owners that aren't happy with their board. And so we're living this real time. But, you know, one of the questions is, can homeowners sanction the board in any way? And I guess the answer is what we just talked about, you know, vote or recall.
Or if there's a board member code of conduct, the board member code of conduct does allow the board to sanction a rogue board member, but that would be a sanction coming from the board, not the owners. To your point, the owner's sanction is a recall or vote them off.
Yeah. We have a question about who management companies can take direction from, and it's a big problem for management companies. And when I say that, I don't mean Castle. All management companies, almost all management companies have clauses in their contract that says if there isn't a consensus, they take their direction from the president. And the reason is, if they don't have that in their contract, you know, they're going to have potentially five board members telling them to do different things. So that was a specific question asked about who management companies take their direction from. Generally, by the way, it is the board, but if there is this not agreement, all of our contracts say that the president will represent the board.
Do you want me to go back to the civility code for residents?
No, let's go to the civility. And it was an interesting conversation you and I had yesterday. Obviously, we wish for civility, but I think you were taking it beyond that. Should we have something in our best practices or our documents about a code for our owners?
It couldn't hurt. And let me say this, because often when I get a call and it's telling me that there is a particular resident and that resident is I just had this last week. Resident is harassing workers who come on, misdirecting them, telling the painter, I don't want you painting here, involving himself or herself where they shouldn't be. But even at a heightened level, I had somebody recently who was taking pictures, aiming her camera into people's units, catching people in semi-states of undress, following people. It had gotten bad. Now, where do we look to the documents for that? You know, a nuisance clause is not going to be a completely perfect fit for that. It is like sticking a round peg into a square hole or vice versa. What will happen with a civility code is, again, at least we are creating a framework for expectations where we can look and say, well, wait a second, you did this, this, and this, and it violates our rule. And then you've got the ability to pursue an enforcement action the way you would anything else, either with fines or suspension of use rights, arbitration or mediation, or ultimately litigation. But this ties in also what we were just saying, James, about the board's not listening to me. Well, sometimes it is also, sometimes you've got a bad board member who's just not going to listen. But sometimes it's the owner's approach, which is you may want to rethink your approach. Stalking, hammering somebody, harassing somebody, threatening somebody. There's a lot of great negotiation webinars out there, online classes you can take. I took one years ago at Wharton, and it was Professor Stuart Diamond fantastic. If anybody's listening, Professor Stuart Diamond at Wharton has one of the best negotiation classes out there. And it really is eye-opening in terms of how to approach your board. I have seen owners successfully turn around their problems with a board by, I should add, not only just running for the board or recalling, but refashioning their communications and their approach.
Interesting. We've obviously hit a nerve here, Donna, because I got a lot of questions. There's some questions coming in about, can the board communicate outside of the board meeting? Because, you know, we want to agree on an agenda. We want to just kind of discuss framework. I don't think the intent here is to make any decisions, but you and I talked yesterday. Clearly, we can all go and play golf together, socialize. There's not a law against that. The law relates to whether we're talking about business, but can a board assemble outside of a board meeting? Yes or no? And two, because it's a two-part question, how do they, you know, kind of get organized, or does it all have to be done in a public forum?
So I hear this on both sides. Owners who complain that the boards are meeting in secret, and board members who say, how can we function like this, that we can't ever talk to each other? So here's the situation. Under Florida law, if you have a quorum of your board meeting and discussing association business, it is considered a de facto board meeting, which needs to be duly noticed and open. Now, there are some exceptions to this, okay? So even if you're all at the pool and you're sitting there and you've got 4 of your 7 directors, that's a quorum, and you suddenly, Joe starts talking about the new pool contract, and, Susan, jumps in with, her suggestions. That's a board meeting, and that should have been noticed and opened. Okay, so the first thing is look around. Do you have a quorum of directors next to you? If you do, are we talking about a association business? If you are, somebody needs to leave or break it up. You can have closed board meetings, but only for 2 purposes. 1, if you're meeting with counsel to discuss proposed or pending litigation, and 2, if you're discussing personnel issues. So you're talking about, your employee and his or her performance. But even under those instances, James, that meeting needs to be noticed, and it needs to be noticed as a closed meeting. Now, sometimes you have to do workshops, right? Well, we want to go meet a vendor, and, or maybe they want to come to Castle, and we're thinking about hiring Castle. Well, you can, but again, you can't go with a quorum of your directors. If you have a quorum of your directors, then invite James into your community, and that's going to be an open board meeting. I think you asked me a second part, and did I address both parts?
Yeah, I can't remember. And I'm now on to the next one, and that is, you said something again, very actionable. Often there's confusion in boards as to whether they have to notice a closed meeting, but we do.
Absolutely. There's an arbitration. I think there's more than one arbitration case on that point. You still have to post that notice.
Okay. I'm going to just kind of, I have had a flow. I want to get to budgets because there's a lot of question about budgets, but there's also a question about elections in here. And I thought one of the questions was, can board members canvass for votes when there's an election? And so I guess let's answer that one, but I do want to go into electronic voting, which I had lower, but I'm going to bring it up because the question's before me. Can board members, so we're in election, and I want to be on the board, can I go door to door and canvass to get James Donnelly onto the board?
Well, this is again where a policy or protocol will come into place. And you need to look at your nuisance clause, because 99% of the nuisance clauses in the governing documents say no solicitation. So if you're knocking on doors, that arguably is solicitation, and you're violating your documents. Which means if you want to do this, amend your documents to say, notwithstanding the foregoing, going door to door to discuss the election does not constitute solicitation. But the division does take a very, very poor view of what they call electioneering. And that would be, number 1, you cannot list who's an incumbent on the ballot, okay? This is for condos and cooperatives. So when you're listing the candidates, you can't say, Susan, Jerry, and Tom are incumbents. So that's a dead no-no. The other thing you can't do is have the board use the email list that they use to send out a blast and say, we recommend you reelect the board. Another big no-no. But this is where boards can, if you've done great things throughout the year, do an end of year report well before it. Not about, but this is what we did. As you well know, James, most members never go to the board meeting, so they don't really know what the board has done. So send out an end of year report. And the other thing you can do is obviously your candidate information sheet can tell people what you're all about, and that gets included with the second notice that goes out. And lastly, you can have a meet the candidates night, which a lot of my communities do, and I'm sure a lot of your communities do a meet the candidates night. And then you can stand up and now since everybody's so used to what we're doing, which is Zoom, do it on Zoom so people can listen. I have a community right now with 8 candidates running. They've never had so many candidates running. But I said, do people know everyone? Most people don't even know half the people running. So that's the better way than knocking door to door.
I love the idea of the meet the candidates, especially in a larger community and where people don't know each other. On the electronic voting, actually, before I ask you that, there's a question on the term limits, and I think it's just is it on HOAs and condos and co-ops? And how does it apply?
I don't believe it's in the HOA statute, but I would have to check that.
Yeah, but on condos, it's 8 years.
It is 8 years, 8 consecutive years.
And the only exception that I recall is if there aren't enough candidates for all the open positions, a board member can stay on. Is that true?
That's one of the exceptions. There's another exception. It's if you get, I believe it's 2/3 of the vote.
Okay, good. So electronic voting, it's really starting to take off finally. I mean, the technology's been there for a while. I know Becker has Becker ballot. There's a lot of great applications out there. Number one, do you recommend it? Number two, is it required? Number three is, can you do a hybrid? Can you do both?
So let's start with, can you do both? You have to do both. So the law says you can't only require online voting. So online voting is a voting option that more and more communities are offering, as you mentioned, just because of the ease of casting a vote. Right now, I can go online and it takes me, if I've registered, it takes me 60 seconds to click and submit my vote. But you still have to offer the paper voting materials for those people who wish to vote that way. Do I support it? Not just because we have Becker ballot and that was my pet project, my baby here, but yeah, I do recommend it because, again, we're talking about Florida. We have a lot of people who don't live here full time. They're seasonal residents, they're out of the state, international owners, and it just increases membership participation for those who want to do it. Our first community years ago, it was a 55 and over community. They've used Becker ballot every year, but now they're up to 80% participation online and only 20% cast paper ballots. And it was the reverse. And making a full circle back to how we started this webinar, James, was about fraud, right? And how does fraud take hold? Well, a lot of times we're talking about election fraud, right? It's the same people on the board over and over again because they want to. By the way, this is not to disparage the hardworking people who remain on the board, but there can be fraud associated with the election. And a lot of times people will say, well, what about fraud with the online voting? Okay, let me tell you this. It is highly unlikely that a skilled, team, a Russian team is hacking into your condo election in Hollywood, Florida. The more likely basis for fraud tends to be with the paper ballots. It's much easier to have a paper ballot go missing and get tossed into a garbage can, as opposed to tracking and doing the same with an online vote. These online votes do have footprints. So you could do a forensic audit whereby if you've got paper materials that just go missing or that have been forged, it's a lot easier for fraud to take hold. So online voting, it's convenient, it's more secure. Most online voting, all online voting companies are going to tell you that, but do your due diligence and ask those questions.
The other thing you mentioned the other day was that other than for a board election in condos and HOAs, condos and co-ops, you can actually go in electronic voting and change your vote up until the time of the meeting, which I hadn't probably thought of, but I didn't realize. Maybe just comment on that.
Well, you can change your vote if you do paper voting too. So if we're talking about a material alteration vote, a reserve funding vote, an amendment vote, James, those are typically done by limited proxy, right? Before the meeting, you mail out your limited proxy. How do you want to vote on this material alteration? But you may decide, you know what, I changed my mind. I did a little more research. If you've paper voted, you just fill out a new limited proxy, or you go to the meeting and you say, I'm revoking my proxy. Here's my paper ballot. It's the same thing online. So online, those type of votes are open and they're subject to change. But in a condo or co-op for the election of directors, that vote's irrevocable. So, and actually with Becker ballot, we have a little box for online for election where you have to click it, where I hereby acknowledge my vote is final and irrevocable. And it needs to be the same thing with paper materials. That has been a source of problems for some communities, though, James, with the paper ballots, that sometimes, particularly in the self-managed communities where they don't know, where they may come down to the office, personnel, the staff member, and say, hey, you know what, I changed, can I get my ballot back? And he or she may not know, and they'll hand them back the paper ballot and let them fill it out again. That's a big no-no under the statute.
Well, I'm glad you clarified that. I think there's a lot of confusion around that. One of the related questions was one of our audience is asking, how does a owner get a list of who the members of the association are? How do they do that?
So you have to make a document inspection request. It needs to be in writing, okay? And you need to request to see a copy of the unit owner roster. Now, the unit owner roster will have the unit owner's name, the unit number, and the address that they've submitted to receive notices. And that's it. It's not going to have the email addresses for people. Now, email addresses are not they're considered privileged and confidential unless somebody has consented to receiving notices electronically. If somebody has consented to online voting, those email addresses are not subject to inspection. So you've got several different buckets of email addresses. And the association may have another bucket of email addresses just as people email, right? And the association may want to email not official notices, but like just social notices of, something's taking place or we're going to have an event. So there's typically several buckets of email addresses. I know a lot of people, the person who requested that, a lot of times they want to get that roster because they want to organize, right? And they want to email people. Problem is, email addresses are typically privileged and confidential with the exception I said. Now, for my board members listening, a lot of times they'll say this person, remember we're getting back to the person who's not acting civilly, the bad actor, they're emailing everybody, Donna. And my first question is, how did they get everybody's email address? It's because a member of the board sent out a thing and had everybody's email address on it. So you've got to be very careful.
They didn't BCC it.
Exactly.
Yeah. Okay. I want to keep going. Boy, it's flying. So I really have a lot of appreciation for our board members right now. Just think of the environment we're in. Everything from inflation to insurance to SB4D and the reserve requirement increases. It is a tough environment. And here we are, we have a fiscal and a fiduciary responsibility to our community, and now it's budget time. And what we found historically is boards understandably don't want to increase maintenance to a point that would upset their constituency, but it's impossible in this environment. So do you have any advice, both legal and not, I guess, Donna, you have so many great clients as well. How would you coach our boards in this really difficult situation that they find themselves?
So I'm having these conversations daily, several times a day. I'm going to talk to our listeners the way I talk to my clients, but this is not legal advice. I'm just going to give you a glimpse into the way I tell my clients. First of all, the law requires you to pass a budget that meets your operating expenses. If you are passing budgets that are artificially low, you are not meeting your fiduciary obligations under the statute. And I know it's tough. Again, I have these conversations several times a day with my clients. And
Donna, sorry, but you said operating. Does that include reserves?
It does. It does.
Yeah.
But by the way,
I just want
Reserve,
the
that's a
audience to
great
know
point,
that.
James. Reserves by their very nature are meant to be funded through the budget. The statute says for condos and co-ops that you have to pass a budget with full, you have to propose a budget. I'm sorry, condos have to propose a budget with full statutory reserves, which up until now was roof painting, paving, and any other item for which the deferred maintenance or replacement cost exceeds 10,000. Now we've got the structural integrity component on top of that. So yes, reserves by their very nature are meant to be funded through the operating budget, along with all your other expenses, and you have to be reasonable. If you are keeping your budget artificially low and supplementing with special assessments, thinking you're being kind to your owners, you're not, and you're probably shooting yourself in the foot with new owners. And I'll tell you why. You've got people in there, and if they're looking at your budget, and let's say you haven't ratified a special assessment yet, but you know a big one's coming because you kept the budget way too low, you're getting people in as new purchasers who may not really be able to afford to live in your community because your budget is not transparent. Now what you're going to do is wind up having more collection issues down the road when you levy that special assessment. You may have people that can just meet the artificially low budget you've passed, but they are not going to be able to meet the special assessment you need to pass to fund the reserves and do all the other things that you didn't account for in the budget. And I know people say, well, we got to keep ourselves competitive. You know, we want to be competitive. We don't want our maintenance to be too high. Everybody's having this problem, okay? If you're in a multifamily building, and particularly if you're close to the coast or on the coastline, everybody's having this problem. So again, my strong recommendation is you need to pass a budget that fully meets your operational needs and funds your reserves. You can still partially fund right now, but starting in 2025, it's going to be full funding. The days of saying we got to keep it at 5% or 6% increase, they're pretty much over.
It's interesting you say this. I think it's really important. I own a couple of investment condos, and I get the budgets because it's that time of year, and I see what full funding is and what my maintenance fee is on the investment unit, and then at the rate that they're reserving right now, and it's like 75% higher full, which they're gonna have to get to. And I really want to reemphasize your point that if we're keeping it artificially low, we're bringing people into our community that are about to be a receivable problem because they're not going to be able to afford their maintenance in 2 years. And the only other thought I would say on that from a management point of view is we already know what it's going to be like in 25. We know where we are now. At a minimum, let's have a plan to get from A to B. Let's not keep it here and then have to jump it up like that. And, Surfside tragedy was the ultimate, tragically, example of kicking the can down the road again and again and again. And so as much as this is...
Remind our listeners, I'm sorry, James, but I would remind our listeners, if we have anybody who remembers the transition from developer control, that first board, first or second boards post-transition, how shocked they were at the real cost to operate the community, because so many developers, obviously they fund through the maintenance guarantee, but they keep those budgetary costs low because they want to move inventory. Yep. But then when they're out of there, the new boards look and they go, well, wait a second, this isn't what really things cost.
Well, you're right. And one of the additional provisions of SB4D is that the developers are no longer going to be able to waive the reserve. So that will get us started in a better place, I think.
Really good point.
Yeah, and I think, Donna, I love your non-legal practical advice. And I really look at it this way. We're running a business. We're the board of directors. And I was talking to one of my clients the other day. They have a $15 million budget. They're running a big business. And you wouldn't run your household and you wouldn't run your business artificially, keeping things low so that you're going to have this event down the road. So I think we're really having this environment is helping socialize our boards to realize they got to get that up, and it's hard to do. And we feel badly for our owners, but you can't avoid reality for very long. One of the questions that came up on the board while we're talking about budgets is what happens when a board doesn't approve a budget?
Well, oh God, I love that question. First of all, when a board doesn't approve a budget or the owners don't approve?
Board.
Well, the board has a fiduciary obligation to pass a budget each year. Remember, I mentioned that. So
Yeah.
your board, you can't punt. That's like the board member who never who abstains from everything because they don't want to make an unpopular vote. That's also not acceptable. By the way, that's one of the things in the board member code of conduct is you can only abstain when you have a true legal right to abstain, which is typically you have some direct or indirect financial tie to the matter at hand. So your board, when a board doesn't pass a budget, you have to pass a budget. The existing budget will roll over, but as we well know, how many years has it been since boards had no change in terms of the expenses? I mean, insurance alone has skyrocketed. So that's two things. You've breached your fiduciary duty and violated the statute twice. You didn't adopt a budget, and you certainly have an existing budget which doesn't meet your operating needs. So that's a problem. And that subjects that board to if it's a condo or co-op board, or even an HOA board, it subjects it to a potential complaint with the DBPR.
I think that's probably the answer to the specific questions on the board is if the board doesn't act as it's required to, that is the remedy. You would go to DBPR. Is that correct?
File a complaint, and then they will investigate, and most likely the association will be fined and will be given a deadline to comply.
Donna, I always communicate that really boards, associations have three sources of money. One is assessments, one is special assessments, and one is a loan. There was a question that came in about surplus, and is that not a fourth source? And really, it's part of assessments. It just happens to be surplus. But there are a couple questions that came in, and how do we move that surplus to the next year? Can we move it to reserves? And is a board and or owner vote required?
So there's two different types of surplus. One is what you're talking about, a budgetary overage, right? So we thought Donna's legal services would be $2,500, and she was so kind, it was only $500. Now we have a $2,000 surplus in legal on the legal line item budget. But then there's other things. So you would move that around. Often those overages will be applied elsewhere in the budget for anything that was underestimated, but occasionally you overestimate things. Those kind of budgets you work into the budget for next year. So maybe next year you reduce the line item for legal and you work it around. Yes, you can put that into reserves. That's not a surplus that is given back to the owners. I get the sense that questioner is like, well, do I get the money? In that case, no. But there is something called a common surplus that is associated with a special assessment. So if we pass the special assessment for $1 million to do a painting and roofing project, and we mercifully came in under budget, our contractors came in under budget, and let's say we have 200,000 common surplus left over. That board has two options. That board can write checks back to everybody in the percentage by which they paid, or they can apply that common surplus as a credit towards a future assessment. And that is in the board's discretion. I do have some boards that when they're dealing with common surplus from a special assessment, they do write the checks back, and other boards that apply it as a credit towards a future assessment.
Okay. So we talked about budgets. We talked about the importance of getting them at the right level. Unfortunately, given inflation, given our maintenance fees are going up, insurance, all that, I'm an owner. I can't pay my maintenance. I literally can't write the check. And we're starting to see this come back a little bit. For the last 10 years, we've not had many problems collecting assessments, but it's coming back. Maybe just kind of walk us through how do we collect the maintenance from owners that aren't paying?
So owners that aren't paying, again, and this gets for you remember the recession. Okay, sometimes, and we've had these conversations, sometimes owners aren't paying. Often they're not paying because they can't afford to pay. Some are being a little more strategic, right? They're paying some things, but maybe they're not paying their association assessments. For any owners listening, you need to understand that paying your association assessments is as crucial as paying your mortgage, because your lender can foreclose on your home and your association can foreclose on your home. So that needs to be completely understood, that it is the most severe consequence that you will lose your unit or your home if you don't pay your assessments. There is James, there's very strict statutory protocol under 718 for condos, 719 for cooperatives, and 720 for HOAs in terms of how you proceed with collections. The law was changed a couple of years ago to require associations to send out a 30-day delinquency notice first before you turn it over to the law firm. Because once it goes to the law firm, what happens? Attorneys' fees and costs get added, right? So the statute, the legislature said we can't have people being subject to all that. There's a 30-day notice. There's a statutory form. Make sure you use the form. Make sure you deal with your, attorney if you don't understand the form. But that form basically says, unit owner, here's what you owe. Here's the late fees. Here's the interest. We need it in 30 days. After that point, it goes over to the law firm. The attorney now we have to send out a 45-day notice before we can do anything. It's called an initial demand letter, right? And then let's say they threw your letter in the garbage, they throw our letter in the garbage. Now we're at 75 days, right? Now we have to send out another 45-day notice in terms of recording that lien and proceeding. What that means is it's a long time. So that 30-day notice, if you're sending out 1, 2, and 3 complimentary notices before the statutory notice, you could be half a year before you start collecting. So you really need to work with management, work with association counsel on your collection policies now, because as you so aptly said, James, we're going to have foreclosures in the coming years because people aren't going to be able to afford to live in these communities. So, and at a time when all these boards also now have to pay for milestone inspections, they have to fund reserves. So sometimes I do think our legislature is a little bipolar, because on the one hand, they're saying, yeah, I do all this. And on the other hand, they're saying they're delaying getting the assessments in.
Well, let me just say this. I mean, this isn't a webinar today on collections, but the one thing I've found and I've been in this business 35 years, the communities that don't have a lawyer-approved, well-written and communicated collection policy and enforce it get in trouble. And it's hard. It breaks your heart because it's your neighbor. But it's just, we're running a business. We have a fiduciary response and fiscal responsibility to run it like a business. And so really the point I wanted to highlight there is we're going to have to dust off our collection policies and we're going to have to enforce them because that 6 months means we may not have the money to pay the bills. And so we're having all of these pressures come on us. One of the big ones is insurance. And I know we don't know what is going to happen, but I know that the Governor DeSantis has called back the legislature, I believe in December. I'm not aware of a date certain, but the plan was to bring the legislature back next month to work a couple of weeks on some solutions. Number one, do you have any more to share on that? And two, do you have any suggestions on what could help? Because we may get our listeners to start calling their legislators to move some good law through here.
Well, I think always that last suggestion is crucial. So if you haven't picked up your phone and called your legislator, you need to. If you don't know who your state senator or state rep is, you can go on the flsenate.gov site, plug in your zip code, and it will tell you who your representatives are in Tallahassee. They need to hear from you because I had clients did 100% increase, 200% increase in their insurance premiums. It's crushing them on top of everything else. So reaching out now, and yes, the special session is supposed to be called in December. I also don't know the exact dates yet. I was trying to find that information out, and I haven't gotten it. But call and let them know that this is the number one thing on your budget. In terms of, I'm sorry, I forgot your first question, James, all these two-part questions.
Yeah, well, I want to keep you on your toes. Can you think of anything specific that our legislatures could do to keep insurance rates down? Like, I don't think there's a magic bullet here. I know we've talked about some limits. We've talked about attorneys, those bad attorneys, Donna, charging too much and too much litigation and bad faith claims. But really, I just wanted to know whether you had any insight on what types of things maybe the legislature could or would do when they get together?
Well, obviously they have to encourage more companies to come in to create more competition to lower rates. They may also, at some point, I think California has an earthquake fund. Florida should probably have a hurricane fund, right? Citizens is acquiring more and more policies now, so they're going to have to look at what Citizens is doing. But Citizens also has very high premiums. There's something that our associations can do, though, James. Remember, 718 says that a board has to use best efforts to obtain insurance in what's out in the marketplace, and right now that's a horror story. But some association governing documents actually put limit. I mean, they'll say what amount of coverage you have to have, what type of coverage, and it may not be commercially feasible right now. So get with your association attorney, get with your insurance agent. You may benefit from an amendment to your documents. I will say one thing though. I've had a couple clients say, we're gonna go without insurance, and all of the owners agree with us. You cannot do that. And by the way, the board members, again, you are sitting in a position where you owe a fiduciary duty. Your unit owners who tell you this is a great idea, they do not have that fiduciary duty. They are not subject to liability as you are. So that is going to be a huge problem. And just touching back on the collection issue, where we feel bad, we don't want to go after people for the assessments. Boards, if you have pending repairs that have been identified by your engineer as life safety issues, and they're telling you have to make these repairs, and you don't make these repairs, you can be personally liable if something happens as a result. I want you to remember that.
Yeah, it's really been an uplifting discussion for our board members on what's before them, but it is tough times. When an environment is such that you have a number of different factors entering at the same time, kind of a perfect storm. Having said that, communities should never be more grateful for the leadership they do have, and many of them are on this webinar right now.
100%, because a lot of times nobody wants to step up. So for the people willing to step up, as you said, during these times with these kind of decisions and the financial pressures, it's incredible that we have people who are willing to do this thankless job.
So we'll say thank you. Well, Donna, we've reached the end. I really think we did one of these open forum town hall last year, and it just gives our audience a chance to get out of the lane that we normally, we talk about reserves or SB4D or insurance, then that's what we focus on. But I think I want to applaud you for your agility today as we weaved in and out of these great questions. But that is all the time we have today, Donna. I'm so thankful because it's Thanksgiving for you and you coming on these association leadership series. And I also want to say thank you so much to everyone that logged in today. Thanks for all your leadership in your communities. It is tough, but we shall get through this too. And we're happy to partner with you. So Don, I think you and I are back up in January. Have a great holiday season.
I'm thankful for you for kicking off this entire series.
Well, thank you, Don.
We've helped. I mean, I hear all the time, I'm sure you do, that we've got people that listen every time, and I know that we've helped a lot of people.
Terrific. Okay, everybody, happy Thanksgiving. Have great holidays. We'll see you next year. Appreciate you. Bye-bye. Thanks, Donna.
Thank you.